Okay, you're good to go.
Thank you, Zoe. Good morning, everyone. Welcome to the Labor and Public Employees Committee meeting this Thursday, March the 10th. And I will convene this meeting at 10:06 a.m. this morning and get started. And with that being said, I will open the floor for remarks by the chairs and the ranking members, starting with Senator Kushner.
Good morning. Good to see everyone here, and I'm ready to start and look forward to a productive day. Thank you all.
Thank you, Senator Kushner. With that, we will go to Senator Sampson, ranking in the Senate.
Thank you very much, Madam Chairman. Delighted to join you folks here today, hoping for a productive Labor Committee meeting, or maybe a less productive Labor Committee meeting, depending on which way you look at it. But thank you very much for the indulgence, Madam Chairman.
You're very welcome, Senator Sampson. Up next, we have Representative Aurora, ranking in the House.
Good morning. Thank you, Madam Chair, and I look forward to our conversations and going through these 14 bills. Let's get started. Thank you.
Thank you, Representative. And with that, we will get started with Roman numeral 3, and this will be bills for review, starting with number 1, House Bill 5252, an act concerning employees, and this will be a JF to the floor. Can I get a motion?
So moved.
Second. Can I get a second, please?
Can you hear me?
I can hear you now.
Okay, second, Rep. Hughes.
So we have a motion by Senator Kushner, a second by Representative Hughes, and the floor is open for discussion. Okay. Representative Aurora, you have the floor.
Thank you, Madam. Thank you, Madam Chair. I think this is a placeholder dummy bill, and as a matter of principle, many in our caucus, including myself, would like to see more language and bills spelled out as we advance them, and for that reason, I will be voting no, and ask other colleagues to do the same. Thank you. Back to you, Madam Chair.
Thank you, Representative Aurora. Senator Sampson, you have the floor, sir.
Thank you, Madam Chairman. Representative Aurora already covered my concern, but I did raise my hand, so I thought I should still follow through. My understanding of our legislative process is that we take input from the public regarding legislation that is proposed. And it's got to not necessarily be in a completed format, but it should be in a format that at least is recognizable as to its objective. And when we don't do that, we end up with bills like this, which is 6 lines, an act concerning employees. And the first sentence is the Labor Department shall conduct a study regarding employees in the state. And this is just a bill that will be used later to be populated with language that the majority wants to see voted on in the House in this particular case, and then the Senate. I just think that is an affront to the process. Bills should go before the public. They should be heard, and opinions should be raised. And then the committee process, what we're doing here today, should be about debating the merits of this particular legislation to decide whether it should become a law. And this effectively skips that entire process by not allowing public input, not allowing the committee to work on this, and ultimately just putting a bill forward that can be moved very easily for final action. And as a result, I'm going to vote no as well. And I just would encourage the co-chairs to remember that the committee process is here. All of us show up for these meetings for the express purpose of debating and improving policies for the state of Connecticut. This doesn't allow us to do it when it's done in this manner. Thank you, Madam Chairman.
Thank you, Senator Sampson, and that is duly noted. I have been in the building next month, 8 years, and as long as I've been sitting on committees, this has been the process. So as I stated, duly noted. Thank you for the comments. I don't see any further hands, so I will at this time ask Madam Clerk to please call the roll.
Of course. This is an act.
I'm sorry, excuse me, Zoe. I do see Senator Kushner raising her hand.
Oh, sorry. Senator Kushner, you're on mute.
I'm sorry, I just thought of this before you call the roll. Representative Porter, Madam Chair, will we be holding the votes open today?
Yes, we will, Senator Kushner, at a time to be determined, depending on how we move throughout the day. I will make that announcement, but we are and will be holding the votes open. Thank you. You're welcome. Madam Clerk, please
Clerk.
call the roll.
This is an act concerning employees. JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Rep Aurora is a negative, is a no.
Senator Cabrera. Representative Sanchez. Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Tigliano.
Tigliano votes no.
Representative Vargas.
Representative Vargas votes yes.
Thank you. Representative Winkler.
Representative Winkler votes yes.
Thank you. And
Thank you.
Just a reminder, since we're holding the votes open, I'm not going to announce any tallies.
Thank you, Madam Clerk. Next up, we have item number 2, Senate Bill 222, and this is an act requiring notice of discontinuing prescription medicine under a workers' compensation claim with JF Lang.
So moved.
Second.
Moved. Thank you. Moved by Representative Vargas, second by Rep. Winkler. This bill requires an employer or an insurer to provide notice to an employee in the Workers' Compensation Commission before the employer or insurer can discontinue payments for prescription medications the employee is receiving under the workers' comp. The bill details how the notice must be made, that the employee has the right to a hearing on the matter, and that no discontinuance or reduction in payment will take place before an administrative judge approves it in writing. The bill also provides for a penalty if a discontinuance or reduction takes place without approval. The floor is open for discussion. Representative Aurora, you have the floor.
Thank you, Madam Chair. This bill, we heard in the public hearing, has some challenges of implementation, which seemed quite important to work out, rather than put the whole availability of the actual medication at risk. So I think there is a possible unintended consequence if we don't work that out. In concept, I want to hear more about the bill. In concept, there seems to be some merit, but in practicality, this bill does not seem to be properly written or vetted out. So for that reason, I will be voting against it, and I ask members of this committee to really consider this fact or this possibility of doing more harm than good at this time. And perhaps there'll be another time, another session to think about it thoroughly. But for now, this is not a properly vetted bill, and I'll be voting no. Thank you, Madam Chair.
Thank you, Representative Aurora. Senator Sampson, you have the floor, sir.
Thank you, Madam Chairman. I'll just align my remarks with Representative Aurora and add that I think this bill is a solution in search of a problem. I believe that there is already an appeals process for situations like this. It seems like a very one-sided proposal and does not look at the potential that the employer or insurer was actually acting appropriately, which is a possibility. I think we'd all have to acknowledge. And I'm just as concerned about, someone being mistreated as an employee or being denied, due process as far as the promises made about their benefits. But I don't think that this bill accomplishes anything positive. There are better ways to approach that, including reforming the appeals process if necessary. And with that, I'm going to be a no as well. Thank you, Madam Chairman.
Thank you, Senator Sampson. With that, I will recognize Senator Kushner. You have the floor, madam.
I believe that the people who testified about this bill brought forward instances that had occurred that were concerning about people not realizing that they were not going to be able to renew their prescription. And that can be serious, and appeals to fill a prescription can take a long time. And I feel like this is an effort to really address a problem. It may not be a widespread problem, which in that case, it probably wouldn't be a widespread need, problem for the employers or the insurers to solve. I recognize that there was some concern about implementation, and I think we should move this bill to the floor. And during that process, we can continue to discuss if there need to be changes made to make sure that it is possible to implement the intent of this bill. So I look forward to my colleagues voting in support of this bill. Thank you.
Thank you, Senator Kushner, and I concur with your statements wholeheartedly. And I will just add that the S language on this bill replaces the word commissioner with administrative law judge for consistency with existing terminology and statute. I don't see any further hands, so I will ask Madam Clerk to please call the roll.
Yes, and this is for Senate Bill 222, an act requiring notice of discontinuing prescription medicine under a workers' compensation claim. This is a JFS LCO 3006. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes no.
Senator Cabrera. Representative.
Representative Sanchez votes yes.
Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano.
Ritigliano votes no.
Representative Vargas.
Representative Vargas votes yes.
Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Clerk. Moving on to number 3, House Bill number 5251, an act concerning workers' compensation for dispatches. JF to the floor.
So moved, Representative Hughes.
Second,
Thank you. And this bill, HB 5251, gives telecommunicators, for example, 911 emergency dispatchers, portal-to-portal workers' comp coverage in two situations. The first one being when responding to a direct order to report to work under circumstances in which non-essential employees are excused from working. And two, after 2 or more mandatory overtime work shifts on consecutive days. And with portal-to-portal coverage, and injury that occurs while the employee is traveling to or from his or her home and workplace is deemed to have occurred in the course of the employee's employment, making him or her eligible to receive workers' comp benefits for the injury. Current law provides portal-to-portal coverage only to police officers and firefighters, and under the same limited circumstances that the bill applies to the dispatchers, Department Correction of employees, and the floor is open for discussion. Representative Aurora, you have the floor, sir.
Thank you, Madam Chair. Now, we heard good testimony on this bill from some dispatchers, and I'm I found that quite. I found that compelling to say to look more into it. It is the question of relative equity which really is the challenge here, because all essential workers who have to report to work, which could include workers who are working in grocery stores and who are working at hospitals, have a similar predicament, in a sense that if it is a snowy day, I think most registered nurses, most doctors, most hospital workers still do go to work and make it there. And a similar thing applies even for during storms for many stores which sell quite important equipment, life-saving or really important materials. So it becomes difficult then to say, well, yes, dispatchers, it's important, and that's without doubt. I'm not questioning that, and I actually agree with that. But then this law was changed in the past to allow for firefighters and police officers, and now I think we have this open question. Now, in the interest of having more discussion, I'm going to support yes in this bill with a limited with this limitation that as this gets to the floor, I would like to have more discussion to see if this is really whether we can really talk about the relative fairness, and as a result, I'm in some sense open to this idea and voting yes for this idea, but with that constraint. Thank you, Madam Chair. Back to you.
Thank you, Representative Aurora, and thank you for your support in getting it out of committee today. Senator Sampson, you have the floor, sir.
Thank you, Madam Chairman. Yeah, I have similar concerns. I'm going to support the bill out of the committee today. I can certainly see that someone that is being required to come to work in dangerous conditions definitely has an exposure that needs to be addressed. I do have lots and lots of concerns with the way this is written and the implementation of it, partly because I think that there is no crucial and very definitive definition of essential versus non-essential employees. Are we talking about essential or non-essential public sector employees some of the time? I know that the bill is limited to certain things, but the notion of who's essential and who's non-essential is something that I think came up during the beginning of the pandemic that I did not appreciate the way the executive branch addressed it, because they arbitrarily decided who was essential and who was non-essential and changed it. If you remember the issue of hair salons, there was a lot of issues there. And so that's a concern partly. And the other thing is, at what point do we continue the drive to and from work to truly be dangerous? driving to and from work is more dangerous than a lot of things already. But we don't extend workers' comp in most cases. Driving to and from work because you're required to be there in dangerous weather, that might be a reasonable accommodation, and that's why I'll support the bill today. But we should find a way to really determine what is considered dangerous weather and really determine whether or not that employee is being asked to do something dangerous more than on a typical day. As I remarked earlier, this is the place to have that conversation in this committee. And we ought to be working on finding a resolution to those questions and putting forward a more complete bill. But as was pointed out by one of the co-chairs earlier, that is sadly the process that we've come accustomed to. So I'm going to support it out of the committee today. Thank you, Madam Chairman.
Thank you, Senator Sampson. And we do take seriously the concerns that have been expressed by you and Representative Aurora on this bill. But we are addressing the issue of exactly what you stated. Essential workers, workers who are demanded to go to work when others are able to stay home and stay safe, are out there, and they certainly should, as you stated, be covered. So I do recognize Senator Kushner. I see your hand up, and I will give you the floor at this time, madam.
Just briefly, I do want to acknowledge the concerns that were raised by our colleagues, and I think we will have, and I encourage us to get in touch with the proponents of this bill. The dispatchers that are involved have been really vocal and have reached out, I think, to all of us about some of their concerns in the last year. I know we've gotten emails, so hopefully we can maybe schedule a call with them to review some of the concerns. I'm sure they'll be available to at least, further their case and maybe get into the details with us. So I would encourage us, and maybe our clerk can arrange for that so that we can continue this discussion. But I do appreciate the support for the bill today, and I'm happy that we're moving it forward. Thank you, Madam Chair.
Thank you, Senator Kushner, and I too appreciate the support. And with that, I would ask Madam Clerk to please call the roll.
This is House Bill 5251, an act concerning workers' compensation for dispatchers. This is a JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes yes.
Representative Aurora.
Representative Aurora votes yes.
Senator Cabrera. Representative Sanchez.
Representative Sanchez votes yes.
Representative Anderson.
Representative Anderson votes yes.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano.
Ritigliano votes yes.
Representative Vargas.
Representative Vargas votes yes. Did I miss a vote previous to this one or no? No. Okay, thank you.
Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Clerk. Moving on, we are at number 4, Senate Bill 221, an act concerning working conditions, and this will be a JF to the floor.
So moved.
Can I get a second, please?
Second from Rep. Hughes.
Thank you. And with that, this bill requires the Labor Commissioner to adopt regulations on safe and equitable working conditions for employees, and the floor is open for discussion. Representative Aurora, you have the floor, sir.
Thank you, Madam Chair. I'll echo my remarks, the ones which I made for HB 5252 earlier regarding a placeholder dummy bill. It's just, as we go through these discussions, it becomes just like what we've been doing for the past few bills, it becomes a little more glaring as we talk about bills in great detail, nuance, just was mentioned earlier by Senator Sampson about the public hearing aspect of it. It becomes very glaring. Why are we doing this? Why are we just passing a one-liner, which is really can be expanded in many ways? Talk about nuances of having, a small change, a two-line change, changing a word here, a word there. This is just an empty two-liner, which can be anything can be written at a much later stage, at which stage it would not have passed the committee process. It would go directly to the General Assembly. It's just a little bit baffling. The reason I'm saying this is I want the public who's tuned in to understand why we are against this idea of these placeholder dummy bills. And many times it's said, well, that's the practice. That's what is always done. And I do not agree with that argument that if we've been doing something which is just not justified or reasonable or in the past, that we should continue doing it in the future. So once again, I will be voting no, and I ask all my colleagues on both sides to really think about this hard and fast, or really thoroughly, that this is not a good idea. Let's just unite on this and not do it. And so I'll be voting a no. Thank you, Madam Chair.
Thank you, Representative Aurora. I see no further hands, so I would ask that the Madam Clerk please call the roll.
Of course, this is an act concerning working conditions, Senate Bill 221. This is a JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson. Okay.
Sorry, Madam Administrator. I had trouble finding my mute button. Senator Sampson votes no.
Thank you. Representative Aurora.
Representative Aurora is a no.
Senator Cabrera. Representative Sanchez.
Senator Sanchez is a yes.
Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Vitigliano.
Vitigliano votes no.
Representative Vargas.
Representative Vargas votes yes.
And Representative Winkler.
Representative Winkler votes yes.
Can you just repeat yourself, Representative Winkler?
Representative Winkler votes yes.
Thank you very much.
Thank you, Madam Clerk. Moving on to number 5, House Bill 5250, an act concerning minor and technical changes to the Workers' Compensation Act. This will be a JFS with substitute language. Can I get a motion, please?
So moved.
And a second.
Second.
Second by Representative Winkler, motion by Rep. Vargas. And with that, this bill makes numerous minor and technical changes. It replaces the term administrative law judge with chairperson in several places in the Workers' Comp Act in order to clarify that certain actions go the chairperson of the Workers' Comp Commissioner rather than one of the regional judges under the chair. It also replaces the term chairman with chairperson throughout the existing law for gender neutrality. And the S language makes that replacement of chairman with the gender neutral chairperson in 31 sections of the existing workers' compensation law. The floor is open for discussion. Seeing no hands, I would ask Madam Clerk to please call the roll.
Yes, this is for House Bill 5250, an act concerning minor and technical changes to the Workers' Compensation Act, the substitute language LCO 3041 JFS to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes yes.
Representative Aurora,
Representative Aurora votes in the affirmative.
Senator Cabrera, Representative Sanchez,
Representative Sanchez votes yes.
Representative Anderson,
Representative Anderson votes yes.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Retigliano,
Retigliano votes yes.
Representative Vargas,
Representative Vargas votes yes.
and Representative Winkler.
Representative Winkler votes yes.
Can you just repeat yourself? I'm sorry. I know people aren't muting themselves fast enough.
Should I speak slower?
I think what you're doing is just fine.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Clerk. Moving on to number 6, Senate Bill number 212, an act concerning permanent partial disability benefits and pension offsets. This will be a JFS to the floor. Can I get a motion, please?
So
Senator
moved, Representative Hughes.
Second,
Second by Representative Vargas, motion by Representative Hughes. And this bill will prohibit municipal pension systems from diminishing or eliminating a retiree's pension rights or benefits due to the retiree's receipt on or after October 1, 2022, of permanent partial disability benefits under the workers' comp laws for partial incapacity benefits or additional benefits for partial permanent disabilities. It also specifies that the prohibition does not interfere with, impede, or diminish the provisions of any collective bargaining agreement negotiated under the Municipal Employees Collective Bargaining Law and in effect before August 1, 2022. The S language is LCO 3184, and this applies the bill's provisions to all municipal pension systems rather than to only those that existed as of July 11, 2007. And the floor is open for discussion. See 2 hands. Who went up first? Senator Kushner, you have the floor, madam.
Thank you, Madam Chair. And I'm very glad that we're taking up this bill this year. Unfortunately, it's been before us before, and we've not ever gotten it across the finish line. You know, we've heard testimony about it, and I have not really heard any good arguments against this bill. This bill really is just a matter of fairness, because when a firefighter or any worker is hurt on the job and they have a permanent partial disability, and just so we're clear, that means that for the rest of their life, they're going to be impaired because of a work injury. Under current workers' comp law, there are settlements basically for this, or maybe not settlements isn't the right word. There's awards that are determined to be fair. And it's a system where there's a schedule of, if you have the permanent loss of part of your arm, it's a schedule of how much money you will receive. If you stay on the job, able to return to work, you receive that over a period of weeks in addition to your wages. So this is not wage replacement. This is actually an award for the permanent loss of a use of a body part. And what's unfortunate is that in some cases, if you are not able to go back to work and you retire onto your pension, your pension's being reduced by that award. There was concern that this might be double dipping. Not at all. If you were working, you would get your full wages and you would get the payment for the permanent partial loss of a body part. So it really, makes a lot of sense to me. I urge our colleagues to vote yes on this bill. I think it's a matter of fairness and something we should have done a long time ago. So thank you, Chair Porter, for giving me the opportunity to address this bill.
Thank you, Senator Kushner. And up next, we have Senator Sampson. You have the floor, sir.
Thank you, Madam Chairman. I just want to make sure I understand the bill that's before us thoroughly. I guess the question I have really is about the collective bargaining agreement. This bill, the way I understand it, would prohibit a collective bargaining agreement from containing language that would suggest that if such an employee did have a partial permanent disability, that their pension could be decreased in conjunction with the award for that disability. Is that correct, Madam Chairman?
I'm sorry, I didn't catch the last part of that, Senator Sampson. Would you repeat that, please? Sorry.
Thank you, Madam Chairman. Just listening to Senator Kushner's description, she described that it's a matter of fairness because if someone is awarded some money for a disability, that should not affect their pension. And in a vacuum, that sounds like a perfectly legitimate statement, but I don't think that's what we're talking about here. We're talking about whether or not a municipality can put something into their collective bargaining agreement with that employee that says that that's what will happen. Is that what the bill actually does, Madam Chairman?
That is, it specifies that prohibition, I'm tongue-tied this morning, does not interfere with, impede, or diminish the provisions of a collective bargaining agreement. That's what this bill addresses when it comes to bargaining agreement. So anything that's negotiated under the Municipal Employees Collective Bargaining Law will not be interfered with. It does not interfere with that.
Understood with. So, Madam Chairman, I understand the concepts of supersedence, which I think is what we're referring to here.
Yes.
But so I'm trying to understand for myself exactly how someone's pension would be diminished because they received an award unless it was negotiated between the employee and the employer, in this case, a municipality.
Well, the pension, I'm sorry.
Be my guest, Madam Chairman. Sorry for jumping in there.
No problem. And I do see Senator Kushner's hand up, but before I call, I will just say that it's diminished because of the payments that are made out due to the disability, and it decreases the pension amount that they would receive. So that is what this bill is attempting to address. And Senator Kushner, I will allow you to weigh in on that since Senator Sampson referred to your statement.
Thank you, Madam Chair. My understanding, I too read the JF language here to say that it doesn't interfere, impede, or diminish. We all can read that. But I think what is the essence here is that we have heard from firefighters and even firefighters that have collective bargaining rights that in certain situations, they have not been able to secure their pensions from the employer for any reason. And I think that we're trying to address that by making sure that this is a basic issue of fairness. Now, in the collective bargaining process, there are times when one side maybe doesn't have the leverage or power to secure a benefit that happens in negotiations. But there's no question in my mind that this is not a fair process and that we should be addressing it in this way through this legislation. So I continue to encourage my colleagues to vote in favor of the bill.
Thank you, Senator Kushner. Senator Sampson.
Thank you, Madam Chairman. I appreciate the comments that both of you fine chairmen have made today, and I am sympathetic to the argument. What I'm missing is what the bill actually does, because it seems to me that if I am a municipal employee and I have a partial permanent disability and I'm awarded some money, that the municipality doesn't have the ability to remove any part of my pension as a result, unless that was previously negotiated between me and them. And I understand that this bill is designed to prohibit such a thing from happening. But if that was a negotiation made eyes wide open between the employee and the municipality, we don't have a right to be interfering with it, in my opinion. I think it's also interesting that we have language that says that we cannot interfere with a collective bargaining agreement, which means that this provision is only going to apply to non-union employees, I'm gathering. I don't know. It just strikes me as sticking our nose in where we don't belong. The employee is a adult person who can learn the terms of employment and negotiate them with the employer, which is the municipality in this case. And there's a contract that they are signing as free adults. We shouldn't be interfering with such a contract. I'm sympathetic to what's happening. And if it was happening in a way that just arbitrarily occurred without the fact that the employee had previously agreed to that arrangement, then you'd have a very strong case. But I don't see that it could happen unless the employee had already agreed to those terms in their employment contract. So I'm going to vote no, Madam Chairman, and thank you for your indulgence.
Thank you, Senator Sampson. Representative Anderson, you have the floor, sir.
Thank you, Madam Chair. I think, we saw some testimony from, I think, Cost and CCM that this, opposing this, but I also, my experiences with the military where I knew people who had the partial disability and it was paid by the Veterans Administration and they were retired, that amount was deducted from their military pension. So it seems like the current law is that principle in work. So I'm going to vote no on this. Thank you, Madam Chair.
Thank you, Representative Anderson. Seeing no further hands, Madam Clerk, would you please call the roll?
This is for Senate Bill 212, an act concerning permanent partial disability benefits and pension offsets. JFS to the floor with LCO number 3184. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Senator Sampson, would you just mind repeating yourself? You weren't on screen.
Yes, ma'am. Senator Sampson votes no.
Thank you. Representative Aurora.
Rep. Aurora is a no.
Senator Cabrera. Representative Sanchez.
Representative Sanchez votes yes.
Representative Anderson.
Representative Anderson votes no.
Can you repeat yourself, please?
Representative Anderson votes no.
Thank you. Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano. Representative Vargas.
Representative Vargas votes yes.
Representative Winkler.
Representative Winkler votes yes.
There you go. Thank you.
Thank you, Madam Clerk. And up next, we have item number 7, and that would be House Bill number 5249, an act concerning non-compete agreements. JF to the floor. Can I get a motion, please?
Rep.
So
Hughes so
moved.
moved.
Second.
Moved by Hughes, second by Vargas. And this is an act concerning non-compete agreements, and this bill limits the use of non-compete agreements and exclusivity agreements. It applies to those agreements into amended, extended, or renewed on or after July 1, 2022. And also under the bill, a non-compete agreement is enforceable only if specific requirements are met, including that the employee must earn at least 3 times the minimum wage, 5 times the minimum wage if they are an independent contractor. And with that, the floor is open for discussion. And I see up first, we have Representative Aurora. You have the floor, sir.
Thank you, Madam Chair. We heard a lot of testimony on this bill, and there were some very good conversations we had. I would like to propose an oral amendment to this bill to change the limits so that the threshold becomes 2 times for regular employees and 3 times for independent contractors. That number makes it clear that regular, not even low wage earnings, more than low, 3 times minimum wages, a 90,000+ annual salary in a short period of time, as our minimum wage gets to the number it is going to get to next year. So I believe that would make us get to what we were hearing, address the issue which we were we really heard that is it okay for somebody who's really working in a restaurant as a in a role which is truly not competitive, and are these non-competes being used? But at the same time, there's a real legitimate reason we heard for protection for business owners, and I think that this bill also clarifies that non-compete should be only used for legitimate business purpose, and I think that's a standard practice in any case, or that's a practice which is adopted by good businesses, which is a majority of them in any case. So I asked the chair to consider an oral amendment which are allowed under the joint rule 5C, oral amendment rule, to change line 115 to say 2 times instead of 3 times the minimum fair wage, and line 117 to say 3 times instead of 5 times the minimum wage. That would address the concerns which at least I have, and allow me to support this bill. And if that's the right terminology, I move for the adoption of the amendment to this bill.
Thank you, Representative Aurora, for the clarity in the end, because I wasn't sure exactly what you were trying to do, but I am clear
Anderson,
now.
like the second.
Thank you. I do see your hand, Representative Anderson, and I will recognize you. I was just trying to make a statement. Thank you. Representative Anderson will be recognized at this time.
I would like to, Madam Chair, I'd like to second that motion.
Thank you. And I'll continue what I was saying. I got distracted by that, but you did state that, you know, companies want to know and how they, and this is proprietary information that needs to be protected. And we did have a lot of testimony. And actually some of the testimony that came from some of the experts did state in many of the cases, employers wanted very clear guidelines. So I do hear what you're saying about the wage and where you believe it should fall in within that threshold, but we intend to keep the language as is. So what I would do is ask the members of the committee to vote no on this amendment and support the language as written. Madam Clerk, I would ask that you would call the roll.
Madam Chairman, please.
Yes, Senator Sampson.
Forgive me, I had my hand up. You didn't.
I'm sorry, I didn't see it. Please forgive me.
And Madam Chairman, I actually don't have a comment on the amendment, but you did not offer the opportunity for discussion. The motion is properly before us. It was moved and seconded. The members should be offered the opportunity for discussion before a vote is taken. And I just wanted to make sure that happened. Thank you, Madam Chairman.
You're absolutely correct, Senator Sampson. Please pardon me. The floor is open for discussion on the amendment before us. Seeing no hands raised, no discussion required. Madam Clerk, would you please call the roll?
This is for Amendment A. Senator Kushner.
Senator Kushner votes no.
Representative Porter.
Representative Porter votes no.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes yes.
Senator Cabrera. Representative Sanchez.
Representative Sanchez votes no.
Representative Anderson.
Representative Anderson votes yes.
Representative Hall. Representative Hughes.
Representative Hughes votes no.
Senator Lesser.
Senator Lesser votes no.
Senator Lesser, I can't see you on screen, so can you just, thank you.
Senator Lesser votes no.
Thank you. Representative Vitigliano.
Vitigliano votes yes.
Would you mind just repeating yourself?
Vitigliano votes yes.
Thank you. Representative Vargas,
Representative Vargas,
Representative Vargas, can you just repeat yourself, please? Representative Vargas, can you just repeat yourself? We'll come back to him in a second. Representative Winkler,
Representative Winkler votes yes. I'm sorry. I apologize. Representative Winkler votes no.
okay. Representative Vargas, are you there? I just need you to repeat yourself. I just missed the tail end of the vote, which is the most important part.
Representative Vargas was muted. I now see he's unmuted, but can say something.
I have a
There you
call.
go.
I have a call coming in.
We can hear you now.
Oh, well, I have a call coming in, but I vote no on the amendment.
Okay, thank you.
Thank you.
Let me just tally it up. Hold on.
It was interfering with my audio and my phone call trying to get in.
And there is a hand from Senator Sampson.
Senator Sampson,
It's for discussion after the vote is
that's what I thought. Thank you. Senator, you haven't tallied the vote yet, have you, Madam Clerk?
No, I have not. I'm in the midst.
We have Senator Cabrera just came into the room. He's driving.
Okay, Senator Cabrera, how would you like to vote?
Is this vote on the amendment?
Yes.
This is an amendment presented by Representative Aurora to decrease the 3 times for minimum wage to 2 times and decrease the minimum wage for independent contractors from 5 times to 3 times.
I believe it was 2.5
Thank
times the minimum wage.
Thank you very much. Yeah, Senator Cabrera votes no.
Okay, give me one moment.
Thank you, Madam Clerk.
Okay, total number voting 12, 3 yes, 9 no, 0 abstaining, and 1 absent and not voting.
Thank you, Madam Clerk. The amendment fails, and Senator Sampson, you have the floor.
Thank you very much, Madam Chairman. I apologize to my colleague for voting against his amendment. It's just something I don't agree with. I do not believe that there should be any restriction on private contracts between adult citizens. I want to remind the committee what our job is. We are elected by the adult citizens of our communities to represent them in the legislature to pass laws that benefit their freedom and their ability to pursue their happiness. When we decide for them that they can or cannot engage in different types of contractual agreements, we are overstepping our bounds. And in this particular case, I find it insulting, as a matter of fact, because it implies that people who make a certain wage or less are not intelligent or qualified enough to enter into an employment agreement of their own accord. I cannot stress enough that this is one of the problems with our economy, the direction of our state and our country, and the reason why Connecticut is not known as a business-friendly environment. There are real-world consequences to a bill like this. And I'll just use the example of the home care agencies. These are businesses that are started by our constituents because they can, and they live in America, where they have the right to start their own industry, and they have an idea to create a business that puts people together. Relatively low wage earning jobs in the home care industry, and businesses and individuals that need those employees. There's a need for that in our society. And the reason why there's a need is because sometimes these people cannot find each other easily. And someone realized long ago that that's a niche. We can create a business out of that, and we will connect these people and we'll take a small fee in the process. But you know what happens when you restrict that employer from being able to make a condition of the employment with the persons that they are connecting? You essentially destroy that industry, because obviously what will happen is the business is going to connect that employee with the employer. And if they don't have any obligation back to the business that put them together, they're going to make their own contractual agreement and cut out that business, which does not improve the lives of anyone, because future people that are in that same situation will not find each other, because that industry won't even exist. I just want to stress that every time the government comes along, and that's us in this committee, and tells anyone that they can or cannot enter into a private agreement of their own free will, we are using force to diminish economic opportunity. Presumably, if someone is eligible to vote in this state, that means they're smart enough to make their own determinations on the policies that they want and who they can vote for. Then why couldn't they be smart enough to enter into a employment agreement, or choose not to based on the terms of it? I just think it's wrong of us to deprive the people that we represent of their own freedom to make decisions. And that's what this bill does. It deprives people of the ability to do that. And it will have far-reaching and damaging effects, no matter what the limit is, whether it's 3 times the minimum wage, 2 times, or even the minimum wage itself. It's the wrong thing to do. And if you are concerned about low-wage workers and they're being taken advantage of, then the best thing to do is to engage them in a way that educates them that they have power in the sense that they don't have to accept employment terms that they disagree with, and employers will have to change what they offer. That's how a free market works. That's how America works, Madam Chairman. And I encourage my colleagues to think hard about the damage that they are doing, not only to the individuals involved, how insulting it is to say that people that don't earn a lot of money are not smart enough to figure this out. And also the idea that when you prohibit economic activity by creating artificial impediments to it, you're lowering the quality of life of every person. This is a big fat no. It's not the thing we should be doing in our committee. We should be encouraging new and innovative business opportunities and contractual agreements to make more production in our society, which raises the quality of life of all parties. Thank you, Madam Chairman.
Thank you, Senator Sampson, for your comments. And I will respectfully disagree. We had several testimonies on this bill, several from national experts, and it's well supported by data and academic research about what happens with these non-compete agreements. And they don't just affect low wage income earners, they affect middle income wage earners. And the example was given in one of the testimonies where, a mom making 80, 90,000, single mom, having 2-3 kids to support, working paycheck to paycheck. So that's the first thing. But you did say, that we represent adults and that it's an insult to them. But I want to counter that in disagreement, because some of the testimony that we had actually stated that oftentimes employees are not aware that they've even signed a non-compete agreement. 1 in 4, many without a college degree. These are the people we're talking about. And many times it's an overreach. This was the testimony that we were given by the experts. And, she stated, and I'm talking about Terry Ellen Gerstein. She talked about reporters for Law 360, phlebotomists, Jimmy John's sandwich shop, WeWork. These were the type of employees that she was representing in these non-compete agreement cases. The economists have documented the prevalence of the non-competes and their impact on people. So when we talk about helping people, I think it's detrimental that, these non-competes, when used inappropriately, actually restrict what you're talking about, innovation, entrepreneurship. It restricts the person's ability to move freely from one job to another. And a lot of the testimony that we heard, those were the examples that were given. And, you know, Rachel Arno was another expert that we heard from. And she talked about the adverse effects on the economy and other employers who want to hire other employees. So you state what you state, but we heard from people during that public testimony that are being impacted, as well as experts that have represented them, that this is a problem and that California actually bans all non-competes. They don't even allow it. And I think that there is going to be stringent ways that we look at it in this bill around what is actually proprietary information versus the experience based. And I think that's where the education needs to occur. And you're right, employees should absolutely be educated, but so should the employers. And I do see your hand up. So before I recognize Representative Aurora, I will give you an opportunity to respond, Senator Sampson.
Thank you, Madam Chairman. I appreciate that very much. You were addressing me directly. And since you are, I feel kind of obligated to restate my case and recognize your concerns. I will just repeat that I don't care how many experts testify to things. This is the United States of America. And in this country, people over 18 are free citizens, and they should be able to engage in whatever private contracts they choose, as long as they are not harming anyone else. It is not the obligation of this body or any government to determine what is legitimate or not. I heard both you and my fellow ranking member use that term. It is not us. It is not the Labor Committee in the Connecticut General Assembly that determines what a legitimate use is for a non-compete agreement or what's legitimate in the contract. That is between those parties. And there's no way you can look at this without recognizing that this is an impediment on freedom. That's what it is. You're telling free people they cannot engage in commerce in a way they choose. And I recognize all the problems that you mentioned and that real people are affected and sometimes they are taken advantage of. There are other solutions to that other than imposing on their freedom. And I would submit to you that California has failed to recognize our American system of representative government and free market capitalism. And I don't want Connecticut to mirror it. And the reason why these things happen and people are taken advantage of is partly because of large government overreach, big government policies like this, which are eliminating the need and ability of workers to actually understand the contract that's before them. We are teaching people to become dependent on the government and dependent on our decision makers on this committee, for example, to decide for them what's best for them. I would prefer to live in a free country where people get to make those choices themselves, Madam Chairman. And that's what I'm speaking to. I am sympathetic to people that are taken advantage of, and they should have recourse if they are taken advantage of through the legal system. And we should make our education system strong enough so that the average kid going to public school in Connecticut understands what private contracts are and what non-compete agreements are. So when they enter the workforce, they know to whether or not to make those decisions for themselves. These non-compete agreements have a place in the real world. And the example I gave is just one of them. And when you use a sledgehammer to say that free people cannot engage in this, you're essentially stifling activity, and you might protect someone who was not wise enough to recognize what they were getting into, but you are also prohibiting people that did from engaging in what is a free and lawful activity and should be. And sorry for going so long, but I feel very passionate about this. This is the reason why I ran for office, Madam Chairman, to protect the rights of individuals to make their own choices. We should not be making choices for people.
Thank you, Senator Sampson. I agree. Same reason I ran for office. And the people have came to this committee and the leaders of this committee with this concern. And I believe that this is a viable solution. And I disagree, but I do so respectfully. Thank you for your comments. Representative Aurora, you have the floor, sir.
Thank you, Madam Chair.
and I think this is what an important aspect of debate in this body and the working of our system is to find common ground, to find consensus, and to make compromise. I'm quite disappointed that other members in the committee did not see the merit in making a compromise and voting or supporting the amendment where we would have a middle ground of 2 times of a lower threshold. Now, the reason I support a lower threshold and I supported this bill and this legislation in some format is because of the amount of bargaining power and the ability to protect oneself in different parts of the economic spectrum. And my colleague made great points about freedom to make contract. It is just that at some point there is a intersection between exploitation and between the freedom that somebody may be able to do something. Economic freedom and political freedom and physical freedom are in many ways interrelated. If you're hungry, you will give up your physical freedom. I understand that. When I had very little money and I was presented a contract like this, I just could not afford to negotiate on the contract because of the certain amount of money, $15 an hour was too big for, I just needed to eat. Whereas when you get to beyond a certain point, and I know it's subjective, and I know what I'm hearing from other members of the committee is that 3 times the minimum wage is that subjective line you draw, or 5 times $150,000 or $140,000 a year is where your economic freedom exists. And I do think that as we increase that number, the cost, which my esteemed colleague mentioned, grows higher and higher as we curtail freedom for employers. And so that essence of compromise, I so miss here. That the discussion was quite robust in the committee meeting, in the public hearing, and to the point there is a line being drawn. It's not as if you're not drawing, others are not drawing this line, or this legislation or bill is not drawing the line. We do agree that, or many of us do agree, and I do understand that my colleague who spoke before me did not, that there are certain things which are not absolute. There is a practicality of exploitation which happens, and it is our job. We are elected to stop exploitation, and to stop a minimum wage employee from crossing over the street because they are not getting enough hours, for example, and suddenly now they get full hours. I feel for it. I want to vote for it. But at the same time, I do believe that if we put the threshold above a certain number, it will cause similar harm to those very individuals, because there will be certain other situations, and it might be professionals, it might be other folks who will not be able to have enough opportunity, or who will, this interference will have other economic costs, and there is no need. As the way the philosophy, and we all have different philosophies as we hear, my objective is always the minimum impact on the laws should be minimal to the extent when they're really needed. Otherwise, individuals have the ability to negotiate with each other and make good bargains. Sometimes those bargains we learn by our experiences, and maybe we do not do a good bargain one time, next time we'll understand that. And maybe the idea of education is important. But however, here there is a subjective compromise to be made, a subjective line to be drawn. And it's a very clear situation here that this legislation or the bill presented in the current form draws a line at a certain level. I have heard nothing as part of when I proposed the amendment from any member or all members who thought the right thing would be not to move that line, as to why. I have made a strong case for moving that line. I'm now moving it. My initial inclination was to move that line to minimum wage, because minimum wage is defined as the exploitative line, that you cannot pay less than the minimum wage in this state and in this country, because we do believe that is not right. There is a certain degree of exploitation going on there. But however, in the spirit of compromise, I heard other members. I was hoping to get enough votes so that we could change the legislation to that level. I purposely said double the minimum wage and triple the minimum wage for independent contractor. And I'm extremely saddened. I'm extremely saddened here to see not a whiff of compromise, not a whiff of really listening to each other across the aisle to basically forge legislation in the true spirit. I know that there will be some, there will be, this bill will be passed because of the way the votes are structured here, or way the lines are structured here. But I do want to point out to the public that we are here. My goal is to find strong compromise and build the most robust laws. We have to exercise judgment, some subjective judgment. And from my side, not only do I feel that the judgment, where my judgment is, but I go an extra step, just as I did from 1 time minimum wage to 2 times, and from 2 times to 3 times, to just build compromise. But sadly enough, there are no takers for compromise. With that, I give it back to you, Madam Chair.
Thank you, Representative Arora. One word that resonated was exploitation. And I have to say that, as stated, many experts testified. There's lots of research to support this. And, it's been said and researched, data supports that these non-competes actually stifle innovation, skew the intellectual policy balance. We're talking about a balance. The incentive to innovate is skewed, and to share information. It limits copyright laws and strict definitions for trade secrets. It's been proven that non-competes disrupt that balance. And I think in this legislation, if you look at it, we actually did attempt to strike a balance there, because the language encourages non-disclosure agreements used by employers. It makes no changes to existing law on trade secret protections, and it clarifies common law preserves all the interests employers may commonly have regarding proprietary protections, and rightfully so. There are instances where this is totally legitimate, but what has been the experience is that many are using strong, very strong non-compete agreements that restrict exactly what we're talking about when we talk about economy and innovation and entrepreneurship, and the ability for a worker to have the freedom to move from one job to another. And I do see Representative Arora, you have your hand raised for a second time. I'm going to go ahead and acknowledge you, to be followed by Senator Kushner.
Madam Chair, I wanted to just respond back to you because you referred to my specific plea for compromise, and that's one of the other things which I really find really problematic. That all you said, I had already acknowledged. The question which I was basically referring to, I thought that was something which you really did not. You were answering or speaking after my comment of compromise and where that subjective line is. And the question here was that experts have said, the point made was that the experts have said that there is exploitation or it does not allow people to move. I already submit to that. The question, the point which I was making is I'm moving the discussion forward, not backward. We're not here to just keep narratives upon narratives.
we're moving let's move the discussion forward. We agree that at certain level it is exploitative, but what we are saying here is that there comes a point where people still may say they need help. You know, I can tell you there's somebody who said, yeah, these non-compete agreements are no good, Harry. He was making a $3.5 million agreement. I don't think anybody in this committee is going to want to help that person. They are totally capable of cutting their own deal at a $3.5 million deal, right? And I just could not stop laughing. I'm like, you better have your own way to figure this out, right? And so the question which we're saying is, it is very clear to you, if it's $1 million contract, it should be. $500,000, you think it shouldn't be. 250, it shouldn't be. You're defining the line at 150,000. And my point has been that 150,000 maybe is a lot for me, maybe not a lot for that person, and maybe not a lot for you or a lot for you. I don't know. But what my point here is that let's just keep it at a level at which all of us can agree that is at a point at which there is a element of mismatch in bargaining power. You know, the person who's making $203,000 might basically even say, well, I'm living paycheck to paycheck. You know, there are people like that who might be there. I don't know. That's just a level of prudence. But I can tell you that somebody who's making minimum wage, we all agree that it's tough. We all agree that there's some the bargaining position does not exist for them by themselves. And so we want to basically, as a committee, come together and build some consensus to have a bill to support them. So once again, I'm not really arguing against this, and I do not want to be portrayed that I'm not sympathetic to that bargaining power on that end. What I'm saying is that the compromise here is being made at 5 times and 3 times. And I think that number is more, if we were to bring that down, it would basically make this a more robust law while protecting those who cannot protect themselves, but at the same time ensuring that folks who have the capacity but should be allowed to make free contracts amongst each other. So I will leave it there. But again, I want to state for the record that for those who cannot at the minimum wage level, at certain economic level, where it's clear that the bargaining power is not with them, without an iota of doubt. I want it to be very clear without doubt that they do not have the bargaining power. And I'm using the minimum wage as defined under law as that level and offering double that as compromise, and I'm finding no takers. So that's where the discussion is, not that, you know, we're not liking that people should be protected or something like this is needed. Thank you, Madam Chair, and back to you.
Senator Kushner, you have the floor, madam.
Thank you, Madam Chair. And I want to encourage all of us to vote in favor of this bill. When you look at 3 times the minimum wage, that would be an annual salary of 40 hours a week of $81,000, $120. And I think a lot of people who are earning $81,000, one could say they're in the middle class. Although I know from my own experience from family members who earn that amount of money, they're having a very hard time addressing the cost of living, and not just in this state, by the way, but across the country. And I feel like $81,000, it's very unlikely someone who's earning that amount of money, if they have a kid or 2, you're paying rent, you might even have a kid in college, I'm sure you would hope to. You're going to have a hard time being able to hire an attorney to fight a case if you had a non-compete and you felt that it was unfair for a variety of reasons that are listed. So, you know, I do think we are drawing a line. I wonder if that line shouldn't be higher, but I listened to the proponents of this bill and realized I wasn't going to try and move the bar higher, because I think people earning $100,000 a year in our country still struggle to raise a family and to meet all of the needs, particularly, as I mentioned, if they have a kid in college. And so, you know, I think 3 times the minimum wage is a fair, bright line that we've created here. And I encourage all of my colleagues to vote in favor of it. We are a democracy, and in a democracy, people elect us to represent their views in this legislature. And I'm happy to represent my district and do what I think is best for the working families of Connecticut. And therefore, I urge my colleagues to vote yes on this bill. Thank you, Madam Chair.
Thank you, Senator Kushner, and thank you for making that salient point. I mean, everything's going up except for wages. And I totally agree that 80,000 or 100,000 is not going nearly as far as it went pre-pandemic, and prices are continuing to soar. So I believe that we have been quite fair with this, and I too would also ask that this committee support this piece of legislation and vote yes. And with that being said, I see no hands raised. So Madam Clerk, would you please call the roll?
Yes, and this is for House Bill 5249, an act concerning non-compete agreements. This is a straight JF. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes no.
Senator Cabrera.
Senator Cabrera votes yes.
Representative Sanchez. Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano. Representative Vargas.
Representative Vargas votes yes.
Representative Vargas, can you please repeat yourself? I could not see you.
Yes, can you see me?
I can see you now. Just repeat
Yes,
yourself.
Representative Vargas votes yes.
Thank you. Representative Winkler.
Representative Winkler votes yes.
There you go. Thank you.
Thank you, Madam Clerk. Moving on to number 8, Senate Bill number 210, an act concerning technical and other changes to the Labor Department statutes. This will be a JFS to the floor. Can I get a motion, please?
Representative Hughes, so moved.
Second?
Second.
Thank you. And as stated, this bill makes changes to the labor statutes. It does have substitute language that repeals rather than amends a statute requiring physicians and APRNs to report certain types of occupational poisons to DOL. It requires employers' experience rates to be divided by 1.125 instead of 1.123 in 2026. And lastly, it removes a provision that would have repealed a statute that requires certain unions to file annual reports with DOL. With that, the floor is open for discussion. Yes, Representative Anderson, you have the floor, sir.
Thank you, Madam Chair. The testimony from Yankee Institute brought to my attention the last 2 lines of this proposed bill, line 726, 727, which is section 31-77, which repeals the reporting requirement, which you mentioned, which appears has been part of state law for over 60 years. And it seems like it would, where it was all the, this is an item that's already required by federal law of private employers. Now it would remove this requirement from public sector unions in Connecticut. It would be a complete loss of transparency for the financial reporting, which is now required of the union to its members. So for that reason alone, I will oppose this proposed bill, Madam Chair. Thank you.
Thank you, Representative Anderson. Any further discussion? Seeing none, Madam Clerk, would you please call the roll?
Yes, this is for Senate Bill 210, an act concerning technical and other changes to the Labor Department statutes. This is a JFS and the LCO number is 3179. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Senator Sampson, can you just repeat yourself, please?
Yes, ma'am. Senator Sampson votes no.
Thank you. Representative Aurora,
Rep. Aurora votes no.
Senator Cabrera, Representative Sanchez, Representative Anderson,
Representative Anderson votes no.
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Retigliano, Rep. Vargas, Representative Vargas,
Representative Vargas votes yes. Oh, let me show my face. Hold on a second.
that would be wonderful. Thank you.
Forgot. Yes, now that I'm on camera, Representative Vargas votes yes on this bill. Thank you.
Thank you. Representative Winkler,
Representative
There you go.
Winkler votes yes.
there you go. Thank you.
Thank you, Madam Clerk. Moving on to number 9, House Bill number 5247, an act concerning the volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act. This will be a JF to the floor. Can I get a motion, please?
Rep. Hughes, so moved.
Second.
All right, so we had moved by Hughes, second by Winkler. The floor is open for discussion, and Representative Anderson, you have the floor, sir.
Thank you, Madam Chair. I do see the reason for this law, that the volunteer fire departments fell through the crack that they're not subject to federal or state OSHA. But I also, all 4 of my towns have volunteer fire departments, are very strapped for cash. And this makes them subject to $1,000 fines for serious violations. So absent that, I would vote yes, but just because of $1,000 fine, I'll have to be a no vote. Thank you, Madam Chair.
Thank you, Representative Anderson. I believe, and I'm just checking, current law allows for OSHA to impose up to 1,000 civil penalty on an employer cited for a non-serious violation. This bill, instead, we're required to issue a written warning for the first non-serious violation by a volunteer fire department. So I just wanted to make that notation, and I do hear what you're saying. Going forward, there would definitely be a $1,000 penalty, but I wanted to make that statement. Any further discussion? Seeing none, Madam Clerk, would you please call the roll?
Yes, this is for House Bill 5247, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act, excuse me. This is a JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Thank you. Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Thank you. Representative Aurora.
Representative Aurora votes no.
Senator Cabrera. Representative Sanchez. Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Retigliano. Representative Vargas.
Representative Vargas votes yes.
Thank you. And Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Chair. Moving on. Number 10, House Bill number 5246, an act extending recall rights of certain laid off employees, and this will be a JF to the floor. May I have a motion, please?
So moved.
Second.
Seconded. I'm sorry, somebody else seconded it.
We have, can we repeat the motion, please? Who motioned?
I moved it.
Vargas, and the second was
I'll
I
second it.
second it.
Oh, go ahead.
Winkler.
I'm
Okay,
sorry.
Fine either
Winkler.
way.
Winkler.
we have a second by Winkler. And the current law requires that hotels, lodging houses, food service contractors, and building service enterprises with at least 15 employees to meet various requirements related to recalling certain employees who they laid off between March 10th, 2020 and May 1st, 2022. And this bill would actually extend those requirements to also cover employees laid off by those employers between May 1, 2022 and May 1, 2023. Among other things, the employers covered by the law must notify these laid off employees about available positions for which they are qualified and also offer the positions to those with the most seniority at the employment site. And with that being said, the floor is open for discussion. Senator Sampson, you have the floor, sir. I was about to give you a promotion.
Thank you, Madam Chairman. I've had that job and enjoyed it thoroughly. Let me just say that the bill that's before us is possibly one of the worst pieces of legislation.
We cannot hear you, Senator Sampson. You need to unmute.
Can you hear me
There you
now?
go. I can hear you now, loud and clear.
I accidentally unplugged my microphone.
You're back.
So as I was saying, this is one of the worst bills on this agenda. And sadly, I have to approach it from that perspective. This bill before us simply extends a law that was passed in the last legislative session. Senator Kushner and I had the great fortune of debating it twice in the Senate because it had gone through the Senate one time, went to the House, was modified, and came back, and we had to do it all over again. I have hours worth of problems with this bill, but I will not take up the committee's time today. But I will say that if it does make it back to the Senate, I am planning to go along on it because I think it really speaks to us overreaching once again, and in ways that are just shocking to me. Connecticut is an at-will employment state. That means that an employer can terminate an employee for whatever reason they choose, and an employee can choose to end their employment at will. That's what that means. This particular bill sets a bunch of parameters up by which employers have to return employees that they have laid off in order of seniority. And if it was just that, it might be worth debating, but it does so in such an unbelievable way because it actually defines an opportunity or a job opening as a job that laid off employee could be trained for. So in other words, if you own a business and you lay off a dishwasher, the way I read this bill, and then you need a cook, you will have to go back and rehire your dishwasher because you can train them to be a cook. And it's much worse than that, in fact, Madam Chairman, because this bill in lines 92 through 97, you can look at this. It says that if you buy someone else's business, and I'm sorry, that's the part about, forgive me, there are so many sections of this bill. Hang on. Since I mentioned where it is. Yeah, it is in lines 125 through 127. The requirements of this section shall apply under any of the following circumstances, and it includes a circumstance where you buy a business. So if I buy a Chinese restaurant and I want to have a Greek restaurant, and the cook was laid off, I have to hire the cook, even though he cooks Mexican cuisine and not Greek cuisine. Because this bill says so. That's not the kind of world that we should be living in. We should be living in a world where we judge people based on their legitimate merit for a position. Employers are not dumb. They're in business to make a profit. They want to have the best possible employees working for them. They should be allowed to choose. Employees should try and put their best foot forward to be the best possible employee for the job so they can command high wages. This speaks to something much larger, actually, that I find happens in this committee, but not in the real world, which is that employers and employees are perceived to be at odds, that they are somehow fighting with each other, and we have to give one an advantage over the other all the time. And that's just not the real world. In the real world, employees work for employers because they choose to, and employers choose to have the employees they have. And they have a common goal of advancing whatever business or industry they're in for the purpose of their mutual benefit. To make policy like this, which is nothing more than an excuse to basically undermine an employer, is just wrong. It is something that this body should be ashamed of doing, actually, Madam Chairman. It goes way too far. Our job is, as I pointed out earlier, is to protect the freedoms of our constituents so that they can enter into agreements and pursue their happiness. That's the foundational point of America, and one that we are getting away with when the government decides it's going to micromanage every business arrangement. There are other problems to this bill, Madam Chairman, but again, I'm simply stating my objection to it, and I will encourage my colleagues to vote no. This is bad policy, and anyone can see that. I don't care what political party you're in. If you think that a business owner should have to rehire employees from the previous owner of the business, even if it's unrelated, because the labor committee in Hartford says so, man, I got to tell you, that's a pretty shocking position to take. But thank you very much, Madam Chairman.
Thank you, Senator Sampson. And I just have to say, I am not ashamed. I do believe this is a great piece of legislation. And with that being said, I will recognize Senator Kushner, my esteemed co-chair. You have the floor, madam.
Thank you, Madam Chair. When the legislature and the governor signed into law this bill last year, it was really, I think, very important because it recognized that COVID had set up a situation that was beyond anyone's imagination. We had not anticipated or expected a pandemic and what its impact on our lives would be. And one of the most serious impacts was that many people got laid off. And this bill, which was passed, was there to ensure that, well, as been said, many employers are good employers who do the right thing without any law telling them to do it. But there are those who don't necessarily do the right thing. And this was particularly enacted to make sure that workers who were laid off and had, devoted themselves to the employer had an opportunity to return to work after conditions were such that the business was rehiring. And so this is a very limited scope. It's limited into the industries that it is attached to. It's limited in terms of time, and it's also limited that it has to be related to COVID. And so I was very proud of the legislature when we passed it last year and when it was signed into law by the governor. I must say that I, as well as my colleagues, really believe that we would be fully back in business this year by May 2022. And I think the need to extend this bill is primarily because we know that some of these industries that are impacted here have not returned fully based on the testimony, not just on this bill, but testimony we've heard from employers, employer organizations, and employees on a variety of bills would indicate that businesses are still struggling to return fully from the impact of COVID. So I think it's a modest extension for a year, and I would encourage everyone to vote for this extension. I do recognize that when it gets to the floor, we'll engage in a debate on all the underlying issues that were raised by my friend and colleague, Senator well, I know we're not supposed to say your name or something. I never got that quite right, but you know what I mean. You know who you are, and I'm saying nice things about you. And so we'll have an opportunity to debate that if it gets to the floor. And we have a disagreement about it, and there are a lot of reasons that I support this bill, but I'll save that for a later date. I think primarily, I just want to focus on the fact that it's COVID related. It's limited in time, and it's related to making sure that people have opportunities to really recover from a devastating pandemic. So thank you so much, Madam Chair, for the time.
And thank you, Senator Kushner, for your comments. Representative Aurora, you have the floor, sir.
Thank you, Madam Chair. I had a lot to say, but my esteemed colleague, Senator Sampson, said it all. I'm going to just echo his remarks and say I agree 100% on this one with him. There's not even any difference. I think he made all the good points. And I would like to say that this is just a wrong idea at this time. We just saw what happened when when COVID was used as a reason to have non-competing bidding process at the state level. What a disaster was that? And yeah, we just need to be reasonable about things. So thank you, Senator Sampson, for making those points. I echo them, and I will be voting no.
Representative Vargas, you have the floor, sir.
Thank you, Madam Chair. I'd like to say that listening to my colleagues from the other side of the aisle, Senator Sampson and Representative Aurora, much of what they say makes a lot of sense. It is true that our small businesses do have a lot of issues that they face, and we have to be very careful of the legislation we pass. But I would like to clarify that this bill is necessary for several reasons. I represent the city of Hartford at the LOB and Connecticut House of Representatives and in this committee. And I've got to talk a little bit about what's going on with our Hilton Hotel. We've had a group of employees there that have worked for many years, are very, very competent in the kind of work they do. But every time the hotel changes hands, the owners come in, they want to lay off all of the employees and hire a new workforce that is non-union. The employees there belong to the Hotel Employees, Restaurant Employees Union, and they've earned their benefits over the years. They've earned good fringe benefit packages. They've earned, relatively good salaries. They've made a good middle-class life working there in that hotel. But when a new owner comes in, they figure they can increase their profit margins by bringing in a new workforce, which is very unfair to people that have devoted themselves to those jobs. So the issues that are raised by my colleagues, I want to address that because I was involved in human resources and labor relations for many years. When I was president of the Hartford Federation of Teachers, I represented all the school employees under the rank of administrator. And that included people that were school police officers, school secretaries, but mostly the largest portion were professional teachers, social workers, school psychologists, guidance counselors. And so it really went from blue collar all the way to white collar professionals. And in my experience, even with union protection, employers can terminate an employee that is not up to snuff for the job through the evaluation process. If a supervisor evaluates an employee and finds the employee is lacking in some aspect, they can issue a letter of warning. If they don't improve, they can suspend them without pay. If they don't improve, they can terminate them, even in union shops. But when it comes to at-will kind of employment, it's much easier to terminate an employee. So in the case of the example that Senator Sampson gave us, which was the case where, let's say someone was a custodian or a dishwasher, and now the only opening available was, let's say, customer relations, and the person was not good at customer relations, there's no reason why the employer couldn't terminate them. The arguments make sense in a way if the bill were to guarantee you lifetime employment or it was ironclad protections. But I don't believe the bill does that. I believe the bill says, yes, if you were a great chef cooking, let's say seafood, but now it's an Italian restaurant, then you have a hard time with the recipes and the clients complain. There's no reason why after an evaluation, you can't let that cook go. So I don't believe the bill actually does what my colleagues from the other side of the aisle think it does. I think it does some minimal things to make sure that employers take into consideration the loyalty, the long-term work that people have done in certain jobs before they make quick decisions about those people. Thank you, Madam Chair.
Thank you, Representative Vargas. And seeing no further hands, Madam Clerk, would you please call the roll?
Yes, this is for House Bill 5246, an act extending recall rights of certain laid off employees. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes no.
Senator Cabrera.
Senator Cabrera votes yes.
Can you just repeat yourself, Senator?
Senator Cabrera votes yes.
Thank you. Representative Sanchez. Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano. Representative Vargas.
Representative Vargas votes yes.
Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Clerk. All right, moving on. Item number 11, Senate Bill number 209, an act concerning the status of probate court system employees, JF to the floor. Can I get a motion, please?
So moved, Representative Hughes.
Second, Representative Vargas.
Thank you. This bill provides collective bargaining rights to probate court employees, including the regional children's probate court employees under the state employee collective bargaining agreement, and the floor is now open for discussion. Seeing none, Madam Clerk, would you please call the roll?
Of course, this is Senate Bill 209, an act concerning the status of probate court system employees. This is a JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes no.
Senator Cabrera.
Senator Cabrera votes yes.
Can you just repeat yourself?
Senator Cabrera votes yes.
Thank you. Representative Sanchez. Representative Anderson. Representative Anderson.
Representative Anderson votes no.
Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Ritigliano. Representative Vargas.
Representative Vargas votes yes.
Thank you. Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Chair. And moving on to item number 12, the last and final item on the agenda for today, House Bill number 5245, an act concerning forced arbitration agreements and allowing certain court actions to be brought on behalf of the state. JF to the floor. Can I get a motion, please?
So moved.
Seconded.
Moved by Vargas, second by Hughes. This bill creates a method for a whistleblower or a representative organization to initiate an action in Supreme Court on behalf of and in the name of the state to enforce certain labor laws. And the example would be public enforcement action, And in public enforcement actions brought under the bill, whenever the state can assess the civil penalty, the court may assess the same penalty. The bill details how a civil penalty awarded by the court would be divided between state agencies and the relator. It also establishes the process a relator must follow, including a notice to the Attorney General's office and anti-retaliation provisions. And then finally, the bill creates a community outreach and workplace account as a separate, non-lapsing general fund account and directs 25% of any civil penalties distributed under the bill to this account. The floor is now open for discussion. Seeing none, Madam Clerk, would you please call the roll?
Yes, and this is for House Bill 5245, an act concerning forced arbitration agreements and allowing certain court actions to be brought on behalf of the state. This is a JF to the floor. Senator Kushner.
Senator Kushner votes yes.
Representative Porter.
Representative Porter votes in the affirmative.
Senator Sampson.
Senator Sampson votes no.
Representative Aurora.
Representative Aurora votes no.
Senator Cabrera. Representative Sanchez.
Representative Sanchez votes yes.
Representative Anderson.
Representative Anderson votes no.
Representative Anderson, can you just repeat yourself, please?
Representative Anderson votes no.
Thank you. Representative Hall. Representative Hughes.
Representative Hughes votes yes.
Senator Lesser. Representative Vitigliano. Representative Vargas.
Representative Vargas votes yes.
Representative Winkler.
Representative Winkler votes yes.
Thank you.
Thank you, Madam Clerk. As I stated, that was the last item on the agenda. And I'm just going to clarify with you, Madam Clerk. I want to announce the next meeting. It is my understanding that that meeting is scheduled for a public hearing on Thursday, March the 15th. And if you could just confirm.
Yes, that is confirmed. I will be sending out a notice shortly. It will be on Zoom. It's a public hearing. Sorry, Senator Kushner, I think she's her hand raised.
Yes, but I was waiting for you to respond.
Yeah, thank you. So it's starting at 10 a.m. on Tuesday, the 15th. You'll be getting a calendar, or you'll be getting information shortly, not a calendar invitation. I'm sorry.
So that is Tuesday, March 15th,
Yes.
10 a.m. Labor and Public Employees Public Hearing. Thank you, Madam Clerk.
Thank you.
And
Sorry.
Senator Kushner, you have put your hand down, so I'm assuming that that was resolved, whatever the hand was for. Okay. Yes, Representative Aurora, you have the floor, sir.
Madam Chair, I wanted us to confirm up to what time we're gonna keep the vote open. I think
Yes, I'm getting to that.
would need some additional time, so it'd be good to give them a couple of hours or more till the end of the day if possible.
Absolutely, Representative Aurora. That was my next statement. And with that being said, the votes will be held open today until 3 p.m., at which time the meeting will be adjourned. Thank you all for your participation today, and thank you to the public who has taken an interest in what is happening with the Labor and Public Employees Committee. Thank you and have a great day.
Hi, Representative Sanchez, you missed some votes.
Okay, thank you.
Let me just go through them really quickly. Okay. Would you like me to read the bill titles or just the bill numbers? What would you prefer?
Bill numbers to save you some time.
Okay, sure. Thank you. So the first one was House Bill 5252, and it's just a straight JF. How would you like to vote?
Representative Sanchez votes yes.
Thank you. You voted on this one. House Bill 5249. How would you care to vote?
Representative Sanchez votes yes.
Thank you. Senate Bill 210. How would you care to vote?
Representative Sanchez votes yes.
And I'm sorry, I should have clarified. Would you like to know if there's substitute language?
Yes, if there is substitute language.
There is,
by the-
yes, there is substitute language. I'm sorry, I should have clarified. This is 5247, and this is just a straight JF.
Representative Sanchez votes yes.
$52.46, just a straight JF.
Representative Sanchez votes yes.
Thank you. Senate Bill 209, just a straight JF. How would you care to vote?
Representative Sanchez votes yes.
Thank you. And you voted on the last one, so you are all set. Thank you very much.
Thank you. Take care.
Hi, Senator Cabrera. Just give me one moment and I will take your votes.
Okay.
Okay, Senator, I am ready when you are.
Thanks so much, Zoe. Appreciate it.
Do you want me to read the bill titles or just the bill numbers? How would you prefer to go through
Need the
everything?
numbers and titles?
Of course I can. And I'll just let you know if it's a JF or if there's substitute language. So the first
Okay.
one is an act concerning employees. It's House Bill 5252. It's just a straight JF. How would you like to vote?
Senator Cabrera votes yes.
Thank you. Senate Bill 222, an act requiring notice of discontinuing prescription medicine under a workers' compensation claim. This has substitute language, LCO number 3006. How would you like to vote?
Senator Cabrera votes yes.
Thank you. House Bill 5251, an act concerning workers' compensation, for dispatchers.
Yep. Senator Cabrera votes yes.
Thank you. And that was just a straight JF. Senate Bill 221, an act concerning working conditions. This is a straight JF.
Senator Cabrera votes yes.
Thank you. House Bill 5250, an act concerning minor and technical changes to the Workers' Compensation Act. This has substitute language, LCO number 3041.
Senator Cabrera votes yes.
Thank you. Senate Bill 212, an act concerning permanent partial disability benefits and pension offsets. This has substitute language, LCO 3184. How would you like to vote?
Senator Cabrera votes yes.
Thank you. You voted on this one. Senate Bill 210, an act concerning technical and other changes to the Labor Department statutes. This has substitute language, LCO 3179. How would you like to vote?
Senator Cabrera votes yes.
House Bill 5247, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act. This is just a straight JF.
Senator Cabrera votes yes.
Okay, and the last one on the agenda is House Bill 5245, an act concerning forced arbitration agreements and allowing certain court actions to be brought on behalf of the state. This is just a straight JF.
Senator Cabrera votes yes.
Okay, thank you very much. I appreciate it.
Thank you so much. Appreciate the help.
Hi, Senator. Hold on, give me 1 second. Okay. All right, so do you want me to just read the bill numbers, or would you like me to read the titles as well?
Me? Yes.
Yeah.
Hi. Just the bill numbers.
Okay. So this is House Bill 5252. This is a straight JF to the floor. How would you like to vote?
In the affirmative.
Can I just see your face, please? I'm sorry.
Yes. Hi, Senator Lester, in the affirmative.
Thank you. All right. Senate Bill 222. This has substitute language, LCO 3006. How would you like to vote?
Lester in the affirmative.
House Bill 5251. This is a straight JF. How would you like to vote?
Lester in the affirmative.
Thank you. Senate Bill 221, also a JF. How would you like to vote?
Lester in the affirmative.
Thank you. This is House Bill 5250, also has substitute language, LCO 3041. How would you like to vote?
Lester in the affirmative.
Senate Bill 212, this also has substitute language, LCO 3184. How would you like to vote?
Lester in the affirmative.
Thank you. House Bill 5249, this is a JF to the floor. How would you like to vote?
Lester in the affirmative.
Senate Bill 210, this is has substitute language, LCO number 3179. How would you like to vote?
In the affirmative.
Fantastic. Thank you. House Bill 5247, this is a straight JF to the floor. How would you like to vote?
In the affirmative.
House Bill 5246, this is a straight JF to the floor. And how would you like to vote?
You'll be shocked. In the affirmative.
Senate Bill 209, straight JF to the floor. How would you like to vote?
In the affirmative. Was that everything?
One more. House Bill 5245, another straight JF. How would you like to vote?
In the affirmative. How many of those were party curiosity?
One more time.
How many of those votes were party line? Oh, well, you're still tallying, obviously, but
Yeah, we're still, I'm waiting on a couple more stragglers, but really, the majority of them were, except for 5251, I think that, and 5250. Those were all unanimous, but every other bill was pretty much, yep, long party lines.
sounds good. Thank you so much.
No problem. You take care, Senator.
You too. Take care.
Yep. Hi, Representative. I can't hear or see you if you're trying to vote. I see you're unmuted now.
Ah, there you go. For a second
Yay.
there, it said you weren't allowing guests to unmute themselves. So I appreciate. How are you, Taylor?
I'm great. How are you, Representative?
Great. I'm sure I missed some votes, so I was hoping that I could log them with you, if that's possible.
You absolutely can. Okay. Would you prefer if I read you the numbers or the full title?
The numbers is fine. I do have the agenda in front of me, so I could follow along.
Okay. So I'm going to start with Senate Bill 212. This has substitute language, LCO number 3184. How would you like to vote?
I am a yes.
All right. House Bill 5249. This is a straight JF to the floor. How would you like to vote?
I'm a yes. Are you obligated to read all the numbers? Because I'm a no on everything else.
I would prefer if we just go through the numbers, just so I make sure I'm understanding everything correctly and there's no confusion.
Fair enough.
Okay.
Thank you very much.
Absolutely. Senate Bill 210. This has substitute language, LCO 3179. How would you like
I
to
am
vote?
I am a no. Thank you.
Yes, sir. House Bill 5247. JF to the floor. How would you like to vote?
I am a no.
House Bill 5246. JF to the floor. How would you like to vote?
I am a no.
Thank you. Senate Bill 209. JF to the floor. How would you like to vote?
I am a no.
Got it. House Bill, nope, you voted on that one already. That one.
5245 should be the last one.
Five two four five. JF to the floor. How would you like to vote?
I am a no.
Thank you. You are all set.
You have a great day and thank you for your patience.
No problem at all. You have a great day as well.
All righty.
Take care. Hi, Representative.
How you doing?
I'm well. How are you?
Good.
You got nick of time. All right.
Yes, indeed.
Would you prefer if I just read the bill numbers or the bill numbers with the titles?
I'm looking at if we're gonna go in order 1 through 12. I'm looking at it right now.
All right, let me get in order then real quick. Sorry. In order. Nope, take that back. I'm reading Zoe's handwriting. I'm going to be a little out of order. I hope that's okay.
Oh, no problem.
All right. So I'm going to start with what's in my hand first. So I have House Bill 5251, an act concerning workers' compensation for dispatchers. It's a straight J F to the floor. How would you like to vote?
Yes.
This is number 5, House Bill 5250, an act concerning minor and technical changes to the Workers' Compensation Act. This has substitute language LCO 3041. How would you like to vote?
Yes.
Senate Bill 222, an act requiring notice of discontinuing prescription medicine under a workers' compensation claim, substitute language LCO 3006. How would you like to vote?
Yes.
This is number 11.
11.
Yep. Senate Bill 209, an act concerning the status of probate court system employees. This is straight JF. How would you like to vote?
Yes. That's 11209, correct? Senate Bill number 209?
Yes.
Yes.
House Bill 5246. This is number 10. House Bill 5246, an act extending recall rights of certain laid off employees. How would you like to vote?
Yes.
Number 9, House Bill 5247, an act concerning volunteer fire departments and ambulance companies and the definition of employer under the State Occupational Safety and Health Act. This is straight JF. How would you like to vote?
Yes.
House Bill 5252, an act concerning employees, straight JF to the floor. How would you like to vote?
5252?
Yes.
Yes.
I'm sorry, yes?
Yes.
Number 12, House Bill 5245, an act concerning forced arbitration agreements and allowing certain court actions to be brought on behalf of the state, straight JF to the floor. How would you like to vote?
Yes.
Thank you. Number 8, Senate Bill 210, an act concerning technical and other changes to the Labor Department statutes. I'm sorry. This has substitute language LCO number 3179. How would you like to vote?
Yes.
Number 6, Senate Bill 212, an act concerning permanent partial disability benefits and pension offsets. This has substitute language LCO number 3184. How would you like to vote?
I'm sorry, what was that again? Oh, number 6, SB?
Yep.
Okay, yes.
One more time.
Yes.
Thank you. I think this is number 4 if I'm reading her handwriting correctly, but it's Senate Bill 221, an act concerning working conditions. This is straight JF to the floor. How would you like to vote?
Yes.
Thank you. And number 7, House Bill 5249, an act concerning non-compete agreements. This is a straight JF to the floor. How would you like to vote?
Yes.
You're all set, sir.
Okay, thank you. Have a good day.
You too. Take care. Real quick, Representative, while I have you, just to be technical and make sure no one nitpicks this, I just need you to state your name and confirm. So I'll just say on items 1 through 12, if you could state your name, how would you vote on items 1 through 12?
Representative Joshua Hall, on items 1 through 12, I vote yes.
Thank you so much. I'm sorry about that.
No problem.